Hi everybody, it's Helen here. I'm so sorry I have to deliver this lecture via the wonders of the internet. And I hope you're well. And I have sent in a couple of emails. If you want to reach out to me at any time, I've given you my personal email, my phone number. If you want counseling services, I can help you with that as well. So, but we get to continue with our class notes. So I'm going to shoot this on Monday afternoon. I'll upload it in a few minutes as soon as I am done talking, and I'm afraid you're just going to have to grin and bear with me. You'll also see in the assessments tab on Blackboard that we've revised some of the journal requirements, and you each have to, well, have a look at the document. And, you know, other than that, the journals are due the same day, the final test is due the same day, and we're just figuring out how to actually accomplish that. What else can I tell you? So as I said, I'm available to you at any time, but we do have to do some lecture notes. Before we get there, let's talk about the role plays. You were divided into groups of 3, so if you can manage to conduct your mediations in any format you wish, but in person, Zoom is good, Skype, whatever you want. Online dispute resolution is a new up-and-coming field, and it is not unrealistic to have a mediation online, exactly like this format. I don't do it too often. I have done it actually once where there was no video, and I am telling you that was not fun. Anyway, so it was by phone only. So anyway, if you cannot connect with your colleagues, everybody has to do another mediation, but go to your family members or whoever is in your household if they're okay to sit with for whatever time it takes to do the mediation. Give them their roles, do the case development, do the mediation, but give them their roles ahead of time so that they can get used to the idea that they are a disputant. And also ask them to play it as they would themselves. If they were in that situation, what would they do? And it's a really interesting process to mediate with people that you probably haven't mediated with before instead of your colleagues. The plus side is you don't really know how people are going to react, and that is the reality of mediation. Okay, to today's class lecture, we're going to be looking at paralegal as a mediator, and in the second section, mandatory mediation and arbitration. So this first video is going to be all about the paralegal rules of conduct, and I'm afraid this is a straight lecture, folks. So the Ontario Paralegal Rules of Conduct, when it talks about Rule 2.01 and subsection 4, outside interest in public office. So I don't know if you want to have your paralegal rules of conduct handy. A paralegal who engages in another profession, business, occupation, or other outside interest, or who holds public office concurrently with the provision of legal services, shall not allow the outside interest or public office to jeopardize the paralegal's integrity, independence, and competence. And 2.015 says, a paralegal shall not allow involvement in an outside interest or public office to impair the exercise of his or her independent judgment on behalf of a client. Okay, so that is your first page. We're going to look at 2.016. This should be screen 3 of your PowerPoint. So, acting as a mediator. So, you can act as a mediator. A paralegal who acts as a mediator, and this again is 2.016. A paralegal who acts as a mediator shall, at the outset of the mediation, ensure that the parties to it understand fully that they are not acting as a representative for either party, but as mediator is acting to assist the parties to resolve the issues in dispute. So there's no confusion on the parties as to what role. That's why in your mediator's monologue you talk about being neutral. You don't represent anybody, and that the paralegal-client relationship does not exist, and that the paralegal acting as a mediator is not providing legal services or legal opinions to anyone. So if you do, of course, you're losing your neutrality immediately. Guidelines suggest this does not preclude the mediator from giving information on the consequences if the mediation fails. So that's basically that reality testing. You know, if this goes to court, how long it's going to take, how much money, stress, blah, blah, blah. You can do a little bit of a, just checking myself here, do a little bit of a reality check, right? That there is a consequence of not going to mediation. And of course, the flip side of that is mediation is faster, it's cheaper, it's less stress, it's private, etc., etc. So, if acting as a mediator, a paralegal must make it clear that they are, again, not a representative. They're a neutral third party whose role is to help them resolve their dispute. You can't represent either or both, even if the one party is unrepresented. Okay, if a paralegal or a member of his or her firm has provided legal services to a party, you can't later mediate that dispute or any related dispute. If the paralegal has mediated a dispute for a party, paralegal, including member of his or her firm, can't later provide legal services in a matter related to the issues mediated. You must refer that out. So hopefully that's pretty self-explanatory. We're moving now to page 4, which looks like that for you, the top part. So this is paralegal profession conduct guidelines, and rule reference is 2.01 subsection 6, and in this the rule reference is 5, and it says a mediator works with disputing parties to help them resolve their dispute. A paralegal acting as a mediator is not providing legal services to either party, which you know. The relationship is not paralegal-client relationship. This does not preclude the mediator from giving information, again, on the consequences should it fail. And when acting as a mediator, the paralegal should guard against potential conflicts of interest, which we just talked about. For example, neither the paralegal nor the paralegal's partners or associates should provide legal services to the parties. Kind of makes sense. Further, a paralegal mediator should suggest and encourage the parties to seek the advice of a qualified paralegal or a lawyer before and during the mediation process if they have not already done so. And my note says here to refer to Guideline 9. Conflicts of interest. For more information on how a paralegal's outside interest may conflict with a paralegal's duties or his or her clients. And again, especially important if the party is unrepresenting. If acting as a mediator, you must make it clear again that you're not a representative of either party, but you're neutral. You cannot represent either or both of them in any subsequent legal matter related to the issues mediated. If a paralegal or a member of his or her firm has provided legal services to a party, you can't later mediate that dispute or any related dispute. If a paralegal has mediated a dispute for a party, paralegal, including a member of his or her firm, can't later provide legal services in a matter related to the issues mediated. Refer out again. Just stay away from it all. Okay, now here's what happens if there is a conflict of interest, and it's similar to what you already know. In the event of conflicts of interest, the paralegal acting as mediator should withdraw from the mediation process unless the parties unanimously consent to continue with the paralegal as mediator despite the conflicts of interest. So if everybody's good with you mediating, you are good to go. Nevertheless, use your judgment to determine whether such a conflict of interest would impair your professionalism and your ability to remain impartial. If at any point the paralegal mediator, you determine that you can no longer remain impartial, you should withdraw from the mediation. So, little story, you know, I love my stories. I had I was to have a mediation several years ago, and one of the lawyers was ironically a friend of the family. And I disclosed to both parties that I disclosed to the other party's counsel that, you know, there was a family history there. And they went back to their clients. Everybody was okay with it. At the end of the day, they settled before they even got to mediation. But, you know, it was distant. Even though it was a family connection, to me, it was important to let that out, because you can imagine what would happen if I was walking down the hallway of a law firm and the lawyer that I've known for literally decades says to me, "Hey, Helen, how are your parents doing?" And the other party happens to be walking by and hears that. It just, as they say, the optics do not look good. So I was up front and they settled anyway. There you go. So mediation, and I believe you're still on PowerPoint tab 4, a non-adversarial process in which a qualified and impartial third party helps the parties to a dispute to resolve their differences. Again, your duty is to be neutral, must have no preconceived opinions or biases in favor or against the other party. No matter how much it's screaming up here, you know something is wrong, or if somebody just did something, it would solve the whole problem. You just can't move forward with that. Acting as a mediator, so we're now at 5. A paralegal who acts as a mediator shall, at the outset of the mediation, ensure that the parties to it understand fully that you're not a representative, you're neutral, you're not acting on their behalf, but you're there to assist them to negotiate. Remember, mediation is what they call a facilitated negotiation, and you are the facilitator. So guideline 2 talks again about outside interests. So we're looking, guideline 2, outside interests. A mediator works with disputing parties to help them resolve their dispute. A paralegal acting as a mediator is not providing legal services to either party. The relationship is not a paralegal-client relationship. Guard against potential conflicts. Okay, for their paralegal, mediator should suggest in the encourage the parties to seek the advice of a paralegal or a lawyer before or during the mediation process if they have already not done so. Okay, so now we're looking at dealing with unrepresented parties, which I believe is tab 5. Screen 5 on your PowerPoint. So paralegal as mediator. Heading, dealing with unrepresented parties. If one or more parties is unrepresented, it is especially important for the mediator to make it clear that they are not acting on their behalf, they are not their representative, providing legal advice to either party. So this is where the mediator will probably, if you realize somebody is unrepresented, you will have to caucus with that person. And what you are doing is you are not leading them anywhere, you are not advocating for them, but you are exploring their BATNA. Hopefully they have figured out, or they have the inclination that they've got a dollar range or some concept in mind. You might need to caucus with them to determine whether or not that's realistic. I don't care how much it costs, I want my day in court. Okay. Let's talk about that, and what does that look like? Just like you saw in the Simmons Funeral Home, when Alan Stitt caucused with Arthur the brother. I mean, they were at mediation, but he was threatening to go to court. You have to have that reality check. In this case, you are making sure that the unrepresented party knows what's going on, has clarified their ideas, and understands the benefits to mediation. And this must be done very neutrally, right? So in caucus, let's say you've got an unrepresented party, you have caucused with them. What do you have to do? You say, thank you very much. Would you just stay here, enjoy your coffee, your tea? And then what you then do is go to the other party, check in. Is everything okay? Do you need to talk about anything? Any clarification? And then you can bring both the parties together. Here's where it's tricky on online mediation, which you might find while you're doing your role plays. You might forget to press the mute button. And, so you've got your two parties on the screen, and you forget to press mute, and the other party can hear you. This is why you have your insurance. So be careful when you're doing your role plays that if you are doing it online and you need to caucus with somebody, maybe the easiest thing to do is I'll get back to you in 10 minutes, however you want to handle that. But it is very, very tricky to remember those mute audio buttons. Okay, so now you're the paralegal as a representative. So we're still on slide 5. As a paralegal, you're advocating exclusively for the best interest of your client. You are not protecting the interests of the opposing party and must make that clear to any self-represented party. So here, we did this in class a lot with the negotiation exercises. You want to prepare them, just like we did with those BATNA worksheets, that you want to prepare them to make sure you have figured out with your unrepresented, your clients, what their BATNA is. What do you think the other BATNA is? You must also figure out that dollar range. So you're going in to negotiate on behalf of your client. You also, don't forget, must have that authority to settle if your client is not going to be with you at the time. So while it says here, you're not protecting the interests of the opposing party, you are going in with, how do I word this? With the idea that you're going in good faith. That's the word I'm looking for. And hopefully, so is the other party. And if you can refer back to that Hacker Star video, which you can still get that link to. I can't remember what class it was. If you go to the link, it'll take you to a Microsoft homepage, I think it is. And you just put in your Seneca username and password, and it'll take you right to the video. So you remember in that Hacker Star, Roger Fisher represented somebody in a neutral way, because he literally wrote the book. And then his buddy was represented by legal counsel. But by the end of it, through this fantastic method of negotiation that he was able to bring everybody to the table to negotiate in a fair manner. So it can be done. And it might, if you've got if you're the other person is self-represented, maybe you take on that role that Roger Fisher did. So if you can hold on to that link and watch it again, why not? Okay. So we're going to flip to page 6, and we're going to look at forums for mediation. And there's a number of different areas that you can mediate. If you want more information on where to go to get more mediation experience like what I'm going to tell you now and what's on our sheet, please feel free to email me even after the semester is done, and I'll help you out as much as I can. So there is community mediation, often available for minimal charge or as a free service. Helps to resolve neighbor conflict, minor commercial conflict, interpersonal problems, typically conducted by volunteer mediators. Example, St. Stephen's Community House. Stevens is spelled with S-T-E-P-H-E-N-S. Now, you might think in community mediation, why can't people just get along? Because they can't. And that's why you're in the field that you're in. Neighbors cannot get along. So, you've got, just think of the stress that you have. Maybe some of you were in residence and you've got somebody playing music loud, or the cooking doesn't meet your expectations of how something should be. What else could I tell you? You share a driveway at your home and somebody's not pulling up the garbage bins. And, anything. dog presence on your front lawn. I think I probably mentioned your fence is on my property line. Any sort of city bylaw violation, anything. A dirty look set off two neighbors in a dispute that tried to go to mediation, but it did not work. Somebody was standing on their front porch. There was a car driving by, and what the person on the front porch saw was the passenger driving by giving that person a dirty look as they went by. So that was so offensive to the one neighbor that they were so distraught. They were living in a townhouse complex that they actually requested to move. They were living on a base up in Petawawa, and they requested to move. And in actual fact, what it's typically a misunderstanding. And what happened was the sun was in the eye of the passenger. And so when they were driving by, they were squinting and couldn't see anything. I'm telling you, this set off such anxiety. Now that's extreme. They were under extreme situation there as well. And so they were tense. But neighborhood disputes are a big, big deal. Okay, there's also government processes. So I'm back to slide 6. Several agencies and tribunals have mediated built into their process, like the HRT and the Landlord-Tenant Board, mediation processes. Mediators are government employees trained and experienced in mediation. No additional charge to parties to participate in the mediation. That's because it's covered by their employer. Could be part of their union or their management structure, or they have something called an employee assistance program, which provides to the company people that deal with mediations, people that deal with an EAP is going to help provide a company with mediators. Also, if there's any counseling that somebody needs, somebody has some personal issues going on, any abuse issues like drug or alcohol abuse. So government agencies that have dispute resolution mechanisms in them, like departments, usually will be very, very active when the government is very financially comfortable. And if there's times of stress, economic downtimes, depending on what it is, I'm not too sure if that's a current scenario, but in previous economic downtimes, those tend to fall by the wayside because people think it's kind of fluffy. So they're great jobs if you can get them, though. So it's, basically full-time pension benefits and all that kind of stuff. So that's great if you can get it. Okay. We've got court mediation, such as the Ontario Mandatory Mediation Program, a case managed civil non-family actions. Mediators could be private mediators, volunteers, or government employees. As I said, if you want any more information on how to learn more about the mediation world, mediation is available everywhere. And I like to say, wherever there's people, there's conflict. Okay, and then there's opt-in mediation. We're still on slide 6. Parties opt to hire a mediator and are responsible for paying the mediator's fees and any costs associated with the mediation. Okay, so we're going to move to page 7 now or slide 7 in your PowerPoint. So mediator qualifications. Mediators are largely unregulated, and that is true. Market forces and reputation prevail. That's also very true. So there's 2 institutes in Canada. There's one called the ADR, the Alternative Dispute Resolution Institute of Ontario and Canada. They have a governing code of conduct, rules of how to move forward, and it is things like treat everybody equally, let people self-govern, always be neutral, and there's basically 10 codes of conduct that address what, can't show bias and anything like that, and must act responsibly. So there you go. Okay, so the ADR Institute of Ontario, of course, is closely linked with the ADR Institute of Canada. The rules of conduct apply across the board. If you become a member of the ADR Institute of Ontario, I believe also you're a member of the ADR Institute of Canada. Don't quote me on that. They have designations. So the ADR Institute of Ontario has 4 designations. Qualified mediator, so that means you have 80 hours of training and you've conducted 2 mediations that are either voluntary, paid for, co-mediation, or on your own. They've got the chartered chartered mediator, which is, I think, 360 hours of training, 15 mediations, et cetera, et cetera. 15 mediations that might be on your own or co-mediated. Don't quote me on that either. You've got a qualified arbitrator, which you can, now, if you remember from that ADR continuum, as soon as you hear the word arbitrator, the clients are losing neutrality. And, I'm sorry, let me rephrase that. The disputants are losing the ability to resolve that dispute on their own, and the arbitrator is now moving into that rights-based process where they are in a position to start making decisions. The arbitration world is really interesting. So what you need for that is a 40-hour course and a written test. These are all things I'm telling you about that are acknowledged by the ADR Institute of Ontario and Canada, I believe. So if you prefer the arbitration process where you are actually now hearing evidence, hearing witnesses, still informal, and you prefer that to the neutrality of a mediator, you can skip the qualified and chartered mediator process and go right to your qualified arbitrator training. It's that 40-hour course. If you want information, and you come out of it having passed the test and done the 40 hours with your qualified arbitrator designation. The next area is what they call a qualified arbitrator. I'm sorry, I lied. Chartered arbitrator. The chartered arbitrator is an entirely different kettle of fish. You have to have, I think, 10 arbitrations. You have to have a letter of reference from somebody who participated in the arbitration, and that I understand must be counsel. In addition to a couple of other pieces, they give the individual no time frame that I can see from getting your your chartered arbitration to actually getting those 10 arbitrations, because they may not be that easy to get. So when I reviewed the arbitration process to get that chartered arbitration process, I didn't see anything about timeline. I did see must have 10 arbitrations. Now, also, an arbitration can have multiple people in a panel, which is really interesting. So you may not be the lead arbitrator. You could be an arbitrator on a panel of 3, possibly 5. You always want to have an odd number to break a tie if there is one. So you can go to the ADR Institute of Ontario. You'll see a menu, and it will talk about, I think, designations, and then it'll say, what do you want? You want your qualified mediator, and it's a drop-down menu, so then you can go and check out what does that look like. If you want any more information, again, do not hesitate to let me know. So now you must have insurance to mediate. It is the same errors and omissions insurance that you have as a paralegal. Or if you want to do both, you can, when you get your insurance, say you're going to be paralegal and you're also going to be mediating. They might provide a package for you. So I'm a licensed paralegal, as you know. I do not provide legal services, and I focus entirely in the mediation world. So the only insurance that I have is specifically mediation related. Mediation is necessary in case you might say something wrong in a mediation and you mess up, and you must have it. So in order to be a member of the ADR Institute of Ontario in Canada, you must prove that you've got insurance. So there's all sorts of places that you can take training. And the neat thing with the chartered arbitrator training is you can take it also online through the ADR Institute. It depends on how you like to learn. I guess nowadays we don't really have much choice. But I know a gentleman who has a course in Toronto. He usually offers it in October. He's very engaging. It's great. It's held at the Ontario Bar Association. And he is really, really interesting and very fun. So back to slide 7. So mandatory mediation programs take into account experience, mediation experience, training, education, and of course something that you know about now, familiarity with the justice systems, and of course references. You can go into, there's the WWW, Attorney General, English courts, guidelines, and et cetera, et cetera. So let's move on now, because now I'm talking for almost half an hour. It's very easy to do. I have a lot to say about mediation. Okay, so now I'm going to have a look at, that's it. That's it. Okay, I lied to you. I printed out something else. Okay, so that's basically the paralegal acting as a mediator. Review your paralegal rules of conduct. It does reference negotiation, drafting documents, mediation, your responsibilities, and we've gone through a number of them now. And feel free again to reach out to me if you have any questions. Okay, so I am going to stop here, take a break, and then we'll get to mandatory mediation and arbitration, which I actually have already touched upon. Okay, thank you very much, and I will post this to YouTube, hopefully. Thanks.